Welcome members, we're now in public session. I just want to advise you again that the committee will be recorded and broadcast throughout Parliament buildings and online. As we're now in public session, I do want to welcome our newest member, Patsy Magowan, to the committee. Patsy, we're very glad to have you with us.
Thank you. We know Thank you, Chair.
You're experienced in the Justice Committee before, and we look forward to working with you. Members, it's proposed that the oral evidence session with the Department of Justice on the Crime and Policing Bill's second legislative consent memorandum will be recorded by Hansard. Are you agreed?
Agreed.
Thank you. Also, we're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approaches to matters under consideration. Anybody who's got an interest to declare in relation to today's business should do so now or when the particular matter arises. Does anybody have anything they wish to declare at this stage? Could I declare that I have an immediate family member who works in the legal profession, please? Thank you. Agenda item 3 is the draft minutes. You'll find those minutes which are from the meeting on Thursday the 3rd of July at pages 8 to 18 to 30 of the meeting pack. Are you content that those are a true and accurate reflection of that meeting?
Agreed.
Yes, and then I'll sign them. Thank you. Agenda item 4 is matters arising. 4.1 is corresponds from the DOJ on Statutory Rule 2025-121, which is the compensation orders disqualified directors proceedings number 2 rules. Can I ask you to turn to page 32 of your pack for the relevant papers? You'll see there the committee has received notice from the department that it has made Statutory Rule 2025 number 21 in order to correct an inadvertent error in the compensation orders, which was number 13, which was not identified until after the rules were made and laid. This corresponds is for noting because the committee considered this corrected SR at its meeting on the 3rd of July, and we agreed at that stage that we were content with the rule, subject to the Examiner of Statutory Rules report. That report will be provided to the committee when it's available. Are members content to note? Yes?
Agreed.
Thank you. Number 4.2 is again DOJ, its response regarding the improving health within the criminal justice strategy and action plan progress report. And then 4.3 is the Department of Health response regarding improving health within criminal justice strategy and action plan progress report. At our meeting on the 19th of June, I'll bring you in a second, Ciara. At our meeting on the 19th of June, we agreed to seek clarification and answers from both the Department of Justice and the Department of Health to a number of matters raised in previous responses regarding the Improving Health Within Criminal Justice Strategy and Action Plan Progress Report. The response from the Department of Justice is located at page 34 to 36 of the pack, and you'll see that DOH's response is at page 39 and 40 of the pack. I would also refer you to item 4.27 at pages 1128 to 1133, and that's the response to the PSNI regarding health needs assessments, which also relates to this matter. So are you content to note the responses from the Department of Health, Justice and the PSNI, or do you require any further information or clarification? Ciara, you had indicated.
Yeah, specifically in relation to 4.3, and I know they're all quite similar in the response, but with regard to the RC, the right care, right person approach, it would be useful just to get a number of questions, just get an update on what specific work is currently being carried out, who's exactly involved, and just where is it sitting at the minute in relation to, because I know they've set up 10 work streams, etc., but I'm very keen to hear, is there any first stages in an implementation point of view, and what that may be. They said there's no timelines or anything, but is there any, why is that? Why is there no specific progress on timelines either? Because I know that it's well over a year, this is a substantial piece of work, there's a range of work streams put set up, but I'd like to know more detail on, what's first up, what's getting prioritised, and when can we see some implementation, and what that may look like. And then the mental health courts, I'm still, I'd love to...
Haven't got there yet, Ciara? Haven't got there yet?
Yeah. Well, it's in the same...
Yeah, I'm coming to that though. So
are you?
Yeah, I'm coming to that. So give me 2 texts. If we just deal with those first 2 for now. So just in terms of taking that forward, then do you want us to write and establish a bit more detail about about time frames and so on the issues you've raised?
Yeah, well, I'd raised the 2, the mental health courts, and that one is in relation to the right care, right approach, but similarly with regard to the mental health courts.
Right.
Which
Sorry, Kel.
4.5.
Ciara, your queries, so hold on, what are your queries relating to? 4.5, are you on 4.2 and 4.3?
4.3, it's the Department of
Yeah,
Health response.
Department of Health.
See, them three responses have a mix of all of them,
Yeah,
Yeah.
but it's specific in relation to the response that came back from the Department of Health.
right.
Okay.
So we can, right, can we? We'll
Yep.
check that out.
Yeah.
Ciara, you content with that?
Yeah.
Members
Is that
content that we do that, yes?
the mental health court, just getting the update there?
I'm going to come there now. So there's two more then, which is the 4.4, which is the response regarding Raises Mental Health Court's paper, and then 4.6, which is from the Minister of Health responding to Raises Mental Health Court's paper. So just to give members a bit of recap, at our meeting on the 3rd of July, we considered the raised paper on mental health courts and agreed that we'd write to the DOJ and the DOH for information on what work on mental health and the criminal justice system is currently being prioritised, both within each department and cross-departmentally. DOJ's response is pages 41 to 44, and Health's response is response information sought by members is to the raised paper is located 50 to 55. Are you content to note those, or do you require further information or clarification at this stage? And at this point, I'm turning to Ciara.
Yeah, I'd like further update on the mental health courts. We're well aware of why they were kind of delayed, but just what specific efforts, if any, are being made now to progress them. And I suppose in relation to that, obviously regarding the multi-agency triage teams, which are seemingly proven to be successful. So can we get an update on that with regard to the rollout? They are working on it. Is there any cost specific to it and to be able to roll it out, etc.? So I'd like further detail on that, because I think they're quite pertinent. And
Yes,
it's a quite pertinent initiative, and we really need to be keeping an eye on it and trying to progress it. So I'd like just more detail regarding if there is a delays on the rollout, why, and what's the cost, etc.
Actually, just to add into that, from my time on the policing board, I don't want to relive all our yesterdays, but from my time on the policing board, there was a stage at which the department was looking to not fund the MAT scheme. So I would like some assurances around that it's going to stay in place.
Mm-hmm.
If it's proving to be successful, then it is about rolling it out, and I would like some reassurances that, we're not going to go backwards.
Yeah.
With regard to that. Does anybody have anything else there? We're content that we would proceed as we've outlined. Yeah, thank you. Okay, moving to 4.5, which is from the PSNI and its response regarding mental health courts and right care, right person. Just to recap again, because we're a couple of months down the line, in relation to the raised paper on mental health courts, we agreed to write to the PSNI to seek an update on the work of the multi-agency Silver operational group that members were made aware of the establishment of during the concurrent meeting with Health on the right person, right care, and that included details of any subgroups that have been established, progress made and work plans, along with associated timelines. You'll find the PSNI's response starting at page 46 of the meeting pack. Are you content to note that from the PSNI, or do you require any further information or clarification?
Note.
All okay with that? Right.
Sorry, would it be useful to ask the PSNI the same questions, just regarding the right care, right approach? Likewise, the Department of Health, because they work quite closely, and they're interdependent on this. So, regarding the approach moving forward, could we ask the PSNI the same question? What, if any, are the delays, and if so, what's the cost?
I have no objection. Does the committee want to do that?
Yeah, it's okay.
Yeah, okay, thank you. Next item then is the LCJ consultation and media access to the family courts. We considered correspondence regarding this consultation by the LCJ's office on the 3rd of July, and at that meeting we agreed that we would seek an extension to the deadline to enable the committee to provide a response. The LCJ's office subsequently agreed to extend the deadline for the committee to the 19th of September. So it's going to be necessary for the committee to agree its response at next week's meeting. However, thus far, beyond, I think, what I said at the time, was it that one I said? I said something ARC. Yeah, no comments have yet been provided to enable committee staff to prepare a draft response for consideration. So if you do have thoughts on that, please send them to the committee office by close of business on Monday. I think it would be remiss of us, having been granted an extension, to not make a submission. So if you have views, please do submit them so that that can be prepared to be tabled at next week's meeting. The only thing that I would say on that is the Lady Chief Justice Committee will remember they gave me permission to attend the opening of the legal year, and in her remarks the Lady Chief Justice addressed this issue and indicated her eagerness that such remarks could be delivered in public and that it would assist with transparency of the courts and understanding of the sentencing processes and the factors that are taken into consideration. She also indicated that she's mindful of the privacy issues that surround that, bearing in mind the sensitive nature of some of those cases. But I think that anything that assists the public to understand the system, to understand the considerations and the factors, because sentencing is emotive and controversial. I think anything that assisted that would be helpful, and if possible I would like those kind of feelings to be incorporated into the committee's response if members were agreed. So, Connie, you want to come in?
Yeah, thanks, Chair. I think just to say I totally concur with what you're saying. I think there's a lot. I think transparency would be very helpful in the family court process. I know it's something this committee's contacted about in regards to other issues. So I totally concur with what you're saying, but with obviously we need to be conscious of some of the sensitivities of the cases and the children that are involved in them too. But I think if we can have a response that reflects that and the balance that can be struck, I think that is possible. So thank you.
That's great, thank you, Connie. The other thing that I should say is in the course of her remarks, the Lady Chief Justice, Connie had mentioned that we had received significant correspondence around issues in the family courts, and members will know that we have had meetings with the Lady Chief Justice and indeed family court judges, as well as the Minister on the subject. The Lady Chief Justice referenced that correspondence that she has received, much of it which will be the same letters that we received, she has read and taken into account where she can. So it's helpful actually that she publicly has indicated that she reads that correspondence. So I think that hopefully will give some comfort to the people who have written to us that this is not something that is taken lightly by the LCJ. The other thing I want to flag up to members is obviously AERC are looking at this issue about cross-cutting scrutiny, and they're having an inquiry into that. I flagged up some issues at our meeting in July, so the committee staff have that. I think those remain. It is very difficult, bearing in mind that something of the hamster wheel that we're in, to actually address some of these cross-cutting issues and to find the best way to do it. So I think there is work that the Assembly needs to do in that regard, but if members have some views on that, it'd be really helpful to feed them in so that those can be put through to that inquiry, because we've all struggled and noted the difficulties that there are to bring even two committees together to discuss issues of really huge import. Actually, I mean, this right person, right care thing is huge and could be really significant for people in Northern Ireland, and yet we've had very little time to come together to take it forward in the way that we might wish. So will members take that on board and feed in comments by Monday, please? Thank you. Agenda item 5 is the Crime and Policing Bill, second legislative consent memorandum, and we're about to hear oral evidence from the Department of Justice. Members, could I ask you to turn to page 58 to 93 of your pack for the relevant papers. We previously considered and agreed to support the Justice Minister in seeking the Assembly's consent to extend a number of the provisions in the Crime and Policing Bill to Northern Ireland. Prior to the summer recess, the Department provided a written briefing advising of several further provisions that it believed required legislative consent. At our meeting on the 3rd of July, Departmental officials were in attendance to provide some initial information on the second LCM, and we requested that the Department provide a written paper updating us prior to today's formal evidence session with officials, which would include any discussions the Department has had with the Human Rights Commission and how the Department considers the interference of provisions regarding access to remotely stored data with Article 8 rights to be necessary and proportionate. Members, the written update from the Department can be found at pages 63 to 84 of your pack. Details of the measures intended for inclusion in the second LCM are set out in the appendix, and that's at page 68. The Department's also now laid a memorandum not seeking consent before the Assembly under Standing Order 42A 4B in relation to this second LCM, and that means that consent is not being sought at this stage. And again, a copy of that memorandum can be found at page 85 of the pack. So the following officials with responsibility for different policy areas are attending the meeting today. And to make this easy then, I'll go through folks who we're going to need at the table. So we've got Andrew Dawson. Andrew, it's nice to see you with us again. Andrew's the Director of Criminal Justice Policy and Legislation. We have Lisa Boal, who's Head of PACE, Policing Policy and Strategy Division. Naomi Magowan, Policy Official around Policing Policy and Strategy Division. Colleen Cartwright, Policy Official, Modern Slavery and Human Trafficking Unit. Jane Maguire, Head of Civil and Family Courts Branch. Susanne Corr, Policy Official, Criminal Policy Branch. Emma Crozier, Head of Violence Against the Person Branch. I feel like we've got half the department. I'm sorry that we're taking up kind of your time, but actually it's really helpful to have you here just in case issues arise as we're looking at this. Andrew, you're very welcome to the meeting, as are the rest of you. Doubtless we'll hear from some of you in due course. Because we know only 5 officials can sit there at any given time, Andrew will hand over to you for opening remarks, and then the guys can prepare themselves. I've got a list of kind of some questions we're going to be asking. So there are some general questions around human rights and code of practice. There are questions around the policing board advisory lists. So whoever, that's going to be Naomi. Maybe Naomi, you need to be joining us at the table. We've got some questions for Susanne around the restrictions on granting replacement driving licences to registered sex offenders in a new name. And we're going to need Emma around the strengthened age verification requirements for online sale of knives, crossbows, etc. And finally, some queries around DOH and Access NI, so whoever can deal with that.
Yeah.
So if that kind of gives you some indications to who we're going to need, hopefully that's helpful, and we'll hand over to you, Andrew, to give us your opening remarks. Thank you.
Thanks very much, and thanks for your time this afternoon. As you say, you've received our briefing paper of the 2nd of September. I suppose it'd be helpful just to recap the position so far and provide a brief summary of the contents of the bill. The bill itself was introduced in the Commons and received its first reading on the 25th of February and completed its Commons report stage and the third reading on the 18th of June, moving to the Lords the next day. The Lords' second reading debate, we understand, is currently scheduled for mid-October. The Assembly approved a first legislative consent motion on 10 measures within the bill on the 23rd of June, and at that point the bill contained 15 parts, 137 clauses and 17 schedules. Just for comparison at this point, and just to illustrate how the bill has evolved, it now contains 16 parts compared to the 15 that were before, 203 clauses compared to the 137, and 21 schedules compared to the 17 that were in a previous version that you may have seen. And as you've said, our objective today is to brief you on a further 10 measures which will be intended to be the subject of a second legislative consent motion on this bill. As we advised in July, 2 of these measures were drafted to include Northern Ireland references at Commons report stage, but were not ready in time for consideration within the first LCM. The intention is for the other 8 clauses to be tabled at Lords Committee stage, and all will then be considered at Lords report stage. The Department also laid a memorandum on the 2nd of September to advise the Assembly that whilst we're not yet in a position to lay the LCM, it's our intention to do so in due course. We did this on advice and in order to provide as much information as possible to assist with the Assembly's scrutiny role, notwithstanding that much of the progress of the bill is outside of our control. To illustrate that point, there's still uncertainty around timescales. We're working to our best efforts on that. We're advised by the Home Office that the Lords Committee stage is currently scheduled for late October to late November. The agreed text of the amendments extending any provisions to Northern Ireland will need to be agreed about 3 or 4 weeks in advance of that, so by about the end of this month or the start of October. The crucial deadline for the Assembly to have considered the legislative consent motion is before report stage commences in the Lords. Lords report stage is currently scheduled for 8th December. There is a risk that the bill could move more quickly than that. Ideally, therefore, and in order to give enough time for further scrutiny and to prepare for the debate in plenary, we are aiming to table the motion for Assembly consideration as soon as possible after the Halloween recess. Turning to the detail of the provisions, it's intended that the following provisions will be included in the legislative consent motion. Firstly, creation of a new child criminal exploitation offence, which criminalises every adult who uses or attempts to use a child under the age of 18 for the purpose of involving the child in criminal activity. And also alongside that, creation of new civil child criminal exploitation prevention orders. And those are dealt with currently at clauses 40 to 55 of the bill. And Colleen is here today to provide any further information you might require on that. Secondly, provision of an enabling power for supporting secondary legislation to be made by the Department for Infrastructure to enable refusal of a replacement driving licence for certain registered sex offenders where approval has not been given by the police. Currently that's clause 94.2 of the bill, and Susanne, as you know, is here to provide further information on that. Third, creation of an offence to make, adapt, possess, supply or offer to supply a child sexual abuse image generator. Currently that's associated with clause 63, and again Susanne can also provide information on that. Fourth, the creation of a new child abduction offence in relation to the detention of a child abroad without appropriate consent. Currently clause 104. Jane Maguire is here for any information on that you might require. Fifthly, provision of a power for the courts to impose stalking protection orders directly at conviction, or even on acquittal if there's enough evidence to suggest that the defendant is still a risk to the victim. Currently that's clauses 97 and 98 of the bill, and I can provide any further information on that. Sixth, provision of a new measure to introduce right-to-know statutory guidance, which aims to tell stalking victims the identity of their abuser at the earliest opportunity, and empower and encourage police to release identifying information about anonymous stalking perpetrators to victims. Currently that's clause 100, and again I can provide any further information on that. 7. The creation of a Northern Ireland policing board and advisory list, and a duty on the police to consult relevant board and advisory lists before employing or appointing an individual. These clauses are currently being drafted, and Naomi's here for any further information on that. 8. Strengthen the age verification requirements for the online sale and delivery of knives and crossbows, and provision regarding the bulk and suspicious sales of knives. Currently clauses 31 to 36, and Emma is here for that. 9. Removal of the supervision exemption from the definition of regulated activity. This is a Department of Health measure which the Minister has agreed to include in this LCM process. It would ensure that all individuals working with children, including where that work is not a regulated activity under the Safeguarding Vulnerable Groups Order and is instead classed as a supervised activity, undergo full vetting. That's currently clause 105. I'm happy to provide you with any further information from what I know on this, and if needs be, also revert quickly to DOH colleagues and write to you in the next few days if there's anything that I can't deal with on that. You should also be aware that DOH colleagues are briefing the Health Committee on this provision today as well. The final provision that we are aiming to include in the LCM then is law enforcement access to remotely stored electronic data. These provisions would create a power for police and law enforcement agencies to extract information from one or multiple online accounts in criminal investigations, including counter-terrorism and national security investigations. Currently that's clauses 130 to 137 and 90 and Schedule 14 of the bill, and Lisa is here to provide any further information on that. On all of these provisions, the Department has engaged with the Northern Ireland Human Rights Commission, who have raised no general concerns. Also, screening of the proposed amendments conducted by the Human Rights Commission concluded that the provisions are compliant with Article 2 of the Windsor Framework, in that there is no diminution of rights, safeguards, equality of opportunity provisions, or discrimination protections arising from the provisions. In addition to the 10 measures outlined above, the bill also proposes to expand the lawful purposes for which the police and other organisations can access the GB Driver and Vehicle Licensing Agency database under current clause 138. The committee, as I understand it, has already been advised that policy development is ongoing to consider whether and in what way this provision should be extended to Northern Ireland. The Home Office has formally responded to the Minister, who is considering their proposal, and she's written to her executive colleagues to test whether agreement is possible, and my departmental colleagues will provide you with an update on that measure as soon as possible. Just to point out also, there is also a possibility that some minor consequential amendments to the broader offence of encouraging and assisting self-harm, and that measure was included in the first LCM. So there may be some minor consequential amendments to that offence, and those may be tabled at Lords Committee stage. We're liaising with the Home Office on the possibility of extending these to Northern Ireland, and we'll update the Assembly on the position as soon as we can. So I hope that's been of some help, and any or all of us are here to take some questions.
Thank you very much, Andrew. Right. There's really only, unless anybody has anything's occurred in the course of Andrew's remarks, there's really only Deirdre and me, so go ahead, Deirdre.
Yeah, no, thanks very much. And I'll probably jump about, so apologies. So I know in terms of the clauses 40 to 45, just around the child exploitation, so the Human Rights Commission had highlighted the need for addressing awareness raising of the new offence, and particularly in terms of making sure that it's robust to meet the requirements of Article 6. So it's just to see what work is going to be done or is being done in that regard.
Call my colleague Colleen up.
Oh, no worries. Yes, thank you.
So, as you'll probably know, there already is a programme of work that was launched back in 2021 to address CCE in Northern Ireland, and then most significantly the Justice Minister, the Health Minister and the Education Minister launched the CCE Action Plan along with a Northern Ireland definition for CCE back in September last year. So we are about a year into that action plan. And it has actions within that around training and awareness. The Safeguarding Board for Northern Ireland is leading on a lot of the actions within the plan, and they are currently developing pathways, guidance for practitioners who are working with children on how to respond to CCE, which includes risk assessment tools, and the department is also currently developing a child exploitation toolkit to go in with that guidance as well, and it's currently in the drafting stages. So there is a large piece of work in that CCE action plan around training and awareness, both for policy and for operational partners as well, and the Safeguarding Board will be doing a lot of that. Once the likes of the CCE offence and the prevention orders come into effect, there will be statutory guidance that goes alongside that, and we will work with the PSNI to develop that. That is very, very early stages at the minute. We've just recently engaged with Home Office around that. They have advised that they will keep us engaged on how that develops and how we will develop a Northern Ireland version of it. There will also be non-statutory guidance as well that will be developed along with partners. So lots of work in that area around promoting, and then once this is live, that will also then be amended in the toolkit that will go into the guidance pathways as well, and SVNI are developing workshops around that too.
It was just in the news today, there's been adoption legislation that went through health in terms of children and young people a couple of years ago, but some of the work hasn't progressed because of funding difficulties. In any of this then, from the action plan, you've touched on the definition. Once this becomes law, is resourcing an issue in terms of this area of work, particularly around children and young people? Has that been an issue up to now, or are you identifying it as a risk going forward?
I believe there has been discussions around resourcing and capacity, especially in the likes of the HSC trusts, because while CCE is classed as a form of modern slavery human trafficking, there is a large safeguarding element, so it does sit as well in the Department of Health. So there has been queries around how the pathways and the guidance are going to be implemented by the likes of social workers and things, but I believe that the majority do seem to be on board now, and that there is that large piece of work and everybody is dedicated to those actions in the CCE action plan. There is going to be a dedicated resource actually. So the Department of Justice and Health had submitted a bid to the Home Office for the rollout of a National Referral Mechanism Child Decision Making Pilot, so the NRM, which is the UK framework for referring victims and potential victims of modern slavery human trafficking. for support. So that bid was successful, and we are hoping that will be operational by early new year, January 2026. And it will sit within Health. It was Health who submitted that bid, but they will get a funded full-time coordinator's post along with that as well. So that person will also be responsible for the likes of training and awareness too, and that will be fully funded.
I suppose just, Colleen, I'm not sure if it's still you then on those 2 points around the AI models designed just around sexual abuse material and images. So again, the Human Rights Commission raised the need for awareness raising of the new offence as a way of even trying to deter potential perpetrators. And then also again the Commission with regards to clause 104 child abduction stressed the need to highlight the new offence. So it's just making sure as part of this work is that being taken into account as well in terms of their, I suppose, considerations of these new offences when they come forward.
That would be Susanne, I think.
Oh, is
Jane,
it
to
Susanne? Right,
comment
sorry.
on
Okay.
each of those.
Sorry, thank you.
Hold on, can I just check before Susanne answers that one? Patsy, did you want to come in on the previous question that Deirdre asked there before we get into child abduction?
It was just the child abduction one I wanted to
Child
come on.
abduction, that's fair.
Okay,
I just
thank
want to
you.
make sure we're all with the right people
Just a quick
on,
one
on this point.
on this point.
Yes, go ahead,
You talked a lot about the statutory guidance. Could you throw some light just on the non-statutory guidance and what work has been progressed to date? Because it is critically important that particularly those groups, community volunteer organisations, grassroots on the ground and neighbourhoods and communities, it's quite pertinent that they're fully aware as well, because they work then very much as like a bottom-up, top-down approach. So they're then working with the statutory agencies, and they may, majority of the time, be the first point of contact that may identify the issue.
The non-statutory guidance that Home Office are developing is extremely early stages. We have only had one initial engagement meeting with them just last week actually around the development of that, so they haven't shared any drafts with us. We're not aware of it, but they have advised that they would keep us abreast of any progress and involve us in it, because we will have to make Northern Ireland adaptations for that, and it will be in partnership with those operational and frontline practitioners. But I don't have anything additional, but more than happy to keep you updated in writing as that does progress and as it's drafted.
Oh, that's great, Colleen, thank you.
So you just a query first of all about the child sexual abuse image generator.
It's just about awareness raising. Well, at this stage we don't have anything in planning it yet, but once we get further with, because we haven't seen the draft provision just yet, but further down the line that will be part of our implementation plan. With any new offence we would take more awareness raising into account, but we haven't got anything concrete yet, but it will be part of the plan.
And that's similar with the child abduction stuff then, is it? Clause 104?
Yes, it will be similar, so we'll action that when we come to the point of implementation. So we've already engaged with the PSNI and the PPS to make them aware that this is proposed, and in due course we'll be engaging, for example, then with the legal profession and just getting the message out there.
And on those issues again, any issues, have they highlighted any concerns or issues at this point regarding awareness raising, or
partners
no?
haven't.
Okay.
No.
It's the same for the child abduction.
Okay. My points are then different. I don't know if you want to bring
Can
that.
we let Patsy come in on this issue then, and then we'll move on to the next. Thanks, David. Go ahead, Patsy.
Can I just ask here, in your briefing document, I'm reading here, talking about the 1985 order, doesn't cover the situation where a child is lawfully taken out of the UK by a parent or guardian or carer, but is detained abroad for longer than the permitted period. Permitted by whom?
Well, it might be whatever has been agreed between the parents, or it might be under the terms of a court order.
That's where I'm trying to get. I can understand if that's the court, but how do you define permission in those instances?
Well, there'll be a definition of appropriate consent in the legislation, but in some instances...
Sorry, but what I mean is it a week? Is it 2 weeks? Is it 3 weeks?
I think it will depend on the facts of the individual case.
Right, okay. I'm not sure about that one. And detained abroad for longer than the permitted period. Surely if they're lawfully there with the lawful parent, guardian, carer, whatever it is, detention is hardly a description you would refer to.
I think that is a concept that
Concept
is
that
already
maybe moves beyond what is interpreted to be the legal period. Whoever defines that, court or whatever.
Again, detention will be defined for the purposes
Right, okay.
of the legislation, but it's, I suppose, the purpose of the new offence is to cover what is a gap in the current
All I'm thinking
position.
of is if the child is with someone they love and loves them, you would hardly refer to it as detention.
I think that's a legal term. Obviously, these
Well,
are
I get where you're going.
these
Now,
are
then
complex and sensitive cases, and I appreciate the point you're
okay,
making.
now,
So
then the final thing is working through this process. Okay, so and we've heard these cases on the radio where, say, mother, father, whatever, is abroad somewhere, remains abroad with the child. What it becomes an offence, but if the person who has the child with them has no intention of ever coming back near the north here or within anywhere in the UK, how do you enforce an offence against that person whenever they're not? Where I'm taking this is, what cooperation or collaboration have you had with, say, the likes of Interpol or indeed international jurisdictions or whatever bodies there are internationally to ensure that there are measures put in place to comply with this, or even extradition processes? What way has that been worked through? I'm trying to get my head around this. As to, it's an offence here, that's grand. Somebody could be before the courts for whatever the offence is, but if there's no extradition methodology, if the person has never any intention of coming back, how is the deterrent aspect of that applicable or enforceable against the person who has committed the offence?
I think you're right. There are practical challenges in enforcement in cases which are cross-border, and it will depend on cooperation with law enforcement agencies in the country
Yes.
where the child is. However, we still think that that it will act as a deterrent, hopefully in some cases. I mean, it's already, and so this is also about making sure that cases of wrongful detention are placed on an equal footing with cases of wrongful removal, where it is already an offence, albeit those same practical challenges can arise, and complementing the civil remedies that are available.
What I'm trying to do is trying to work this through as to where the department has done some collaborative work with other jurisdictions to make this doable, workable. What are the best practices that you can work through? How do you actually ensure that a child, which usually a child, is brought back home or encouraged back home to with their parents or loved ones or whatever it might be? I'm just trying to get my head around that and how the department has been working that through internationally and collaboratively with other jurisdictions.
I suppose it's an issue that can arise in other situations that wouldn't be within my own area of expertise, and I suppose it's going to come down to which country a child has been taken to, and what the particular for example, whether there's an extradition arrangement. But I think certainly the evidence that was given to Parliament by Reunite UK, which is one of the leading charities in this area, felt that it would be helpful, and even that it would allow the parent who remains in wherever the child has been taken from, maybe to seek the assistance of law enforcement agencies in that country, and that certainly for some parents, the prospect of facing a criminal penalty would be a deterrent. I think it might be helpful if there is an extradition arrangement, maybe with a country which isn't a party to the Hague Convention, so you don't have access to the civil remedies under that. So there are practical advantages, and say in terms of the actual enforcement, I think it'll depend on the country and the particular relationships and cooperation.
I'm still coming back, I'm not trying to bench you in this, but I'm trying to establish just the practical outworkings of it. Have you liaised with the PSNI to see how they might see different avenues or practical avenues at international levels, potentially through Interpol with this?
We've certainly had made the PSNI and the PPS aware that of the proposed new offence. They hadn't raised any operational difficulties from their perspective. I suppose they're familiar maybe with the offence that already exists under the child abduction legislation.
I'm just trying to work through the practical application of this. And if they any ideas, if they don't have any ideas how to work around it, well, then maybe they should have.
Yeah, as I say, we haven't had a discussion at that detail, but they certainly are aware, and they haven't raised any concerns.
I'm not trying to say concerns, I'm trying to say opportunities, way to work through this legislation, way to see how people can, in fact, bring back their youngsters, get their youngsters back to where they should be. I would hope that the police would have some ideas as to how they might work with Interpol around these issues, especially if you're changing the legislation. But anyway, that's their gig. You may well wish to raise it with them. Thank you very much, Chair.
Thank you, Patsy. And those are helpful questions, and I mean, issues that we'll have. I mean, if these things are supposed to deter, how's it going to work in practice? So helpful. Thank you, Kira. You wanted to come on the same
Just
issue?
a quick one, and I probably don't need to answer now, Jane, but it'll be really useful because there is a lack of awareness even internally within the north of Ireland and GB and how it all works, as you say, regarding child abduction, even internally when you're moving from one part of the north to go to England. I would deal with a lot of cases on that, so it'd be useful just to get the lie of the land regarding child abduction currently as it stands, even internally within the North, GB, UK, whatever, and then obviously what's changing in relation to all the other countries as well, because, and we've spoke earlier about how important it is to raise awareness, even locally. I deal with cases quite regularly, and the parents aren't aware, you know, so it'd be useful just to know even the current legislation where it sits. Even a quick summary of it would be really useful for myself in particular, you know.
Yes, in writing with that.
Yes, in writing. No, that's fine. No, I wouldn't expect it to be here, but I think it would be really useful as well.
Go away and provide something to you, absolutely.
Right. Thank you, Jerry. You've more stuff?
Yeah, just I think 2 or 3 more. Sorry, it's just a bit on the clause 94 RSO. I think it referred in the PEC just saying that the infrastructure minister is now agreed in principle. Has that been done officially then now? So it's just to get in, because I know this has been raised before.
Officially in principle, yeah. Because I suppose we haven't got the clause yet. You know,
Yes.
it can't be finalised. But yes, in principle, she's supportive, and the practicalities will be worked through with officials from both departments.
Okay, no worries, thank you. The other bit was around just the access to remotely stored electronic data. So again, it was just obviously the Human Rights Commission had highlighted concerns around the requirement in terms of the Home Secretary of a code of practice, and obviously also in terms of the consultation with the Justice Minister on publishing a code of conduct. So when will those be available, and will we have sight of them?
So the Human Rights Commission has said that the code of practice would be a very useful tool in ensuring appropriate safeguards were in place regarding the exercise of these new powers, and they were happy to work with us on that. So Home Office will take the lead in drafting that code of practice. I don't think that work started yet because I think their capacity has been focused on the actual legislation, but they plan to turn to that next to start drafting that. There'll just be a code of practice. So Home Office will be turning their attention to drafting that, and there's requirements then for the Home Secretary to consult with the Information Commissioner and the Investigatory Powers Commissioner in drafting that code, and they'll also be consulting with the Education Minister. So I expect they'll be in contact with us at official level once they start to take that work forward, and we can obviously keep the committee updated on that as and when it progresses.
But will that be in line or before the LCM is being agreed or not?
It won't be before the LCM is agreed, but it will be drafted and in place before the powers are commenced. So the LCM will give consent for the powers in the bill, but once the bill achieves royal assent, those particular powers won't be commenced until the code of conduct or until the code of practice is agreed and put in place in statute. Then, so
What you're asking is to agree on LCM on a code of practice we haven't seen. So it's just to highlight that as a concern.
the code of practice, the Home Office won't be commencing the measure until the code of practice is in place. So I think that's an important assurance.
Yeah, but we have no oversight of what that is then, or no
Yeah,
control.
because the work hasn't started yet.
So, well, I'm just highlighting it that that's a concern. The other bit then is just around the health. So I suppose it's the proposal coming from the health in terms of clause 105, the removal of supervision exemption. So it was probably just 2 queries rather than, so it's just really because this could potentially increase the work around additional checks for excess NI. So has the department an estimate on any additional numbers? Have you a sense of what that would, the implications of that? And then the other bit around has funding or indeed support in terms of the knock-on effect then of this around community and voluntary organisations and increased workload to them around this clause and what the Department of Health are asking for. So has there been any analysis done?
So I haven't seen any impact assessment of that, but I can liaise with my health colleagues after today. They're briefing their committee today too, so I'll liaise and then provide you with some information on that.
Okay, thank you. Cheers, that's me, Chair.
Okay, thank you, Deirdre. Does anybody else have anything? Anybody online or anything? No, I just have a couple, and compared to those, it'll be fairly straightforward, I would think. To be honest, I appreciate that this is an LCM and not in your gift, but I think some of the sentences in here are risible, to be honest. I don't see them as deterrents, but that's a matter for His Majesty's Government. Anyway, my queries are, my first query relates to the barred lists. So that's going to be Naomi. Thank you. Naomi, so from reading the paper, I'll speak while you're getting your seat. So from reading the paper, it seems to me that there was an intention that there would be a number of bodies who would, to whom this would apply, and now it's just moving to the PSNI. And the issue seems to be there's capacity issues. I suppose I would like some understanding as to what that means, because, you know, from a layperson's point of view, and that's me, I look at that and say, but it's just about including people in a list, so what's the issue? And the other thing is, does this not mean there's a gap then? If it's only applicable to the PSNI, is there not a gap where people can move between some of these services and it's not going to be caught?
Yes, so yes, it is regarding capacity within the bill that it is reduced back to the PSNI at present. There still would be the intention down the line to hopefully include the other bodies, but it was just, it's purely down to capacity that...
But that's, I suppose, what I want to understand. I get that it's capacity.
Yeah.
But I look at that and think, but is it not, you know, what is it that's going to take up the capacity? Because it seems to be, you know, just listing bodies that it's applicable to. What's going to take the additional resources? So, what's the issue?
So at present, we've provided drafting instructions to the Office of Parliamentary Counsel, and those drafting instructions are to create the lists on the face of the bill. So at present, the clauses that are in the bill just relate to the UK bodies, creating a list for CNC and British Transport Police, for example, and NCA. But we had seen the bill as an opportunity to create the list for Northern Ireland, to try and create a more cohesive sort of environment that all the regions of the UK have equivalent lists, really. So we've been providing those draft instructions then to OPC, which it's going to mirror the England and Wales provisions. So
this is going to be way down the line, isn't it?
Well, no, hopefully this will be on this bill, and they're hoping to introduce it at Lords Committee stage. We would then, it's providing the power to create the lists. We then would be enacting regulations which are more about the actual process of the lists as such, or the procedures involved in them. So it's not as simple as on the list of listing the organisations. It's going to be, it's the full creating the lists themselves on the face of that bill.
You'll forgive me, I'm still not seeing that this is a massive thing, because creating a list is creating a list. You know, and I appreciate it's not you, it's, I mean, OLC or whatever, but like, it just seems bizarre to me. And in the interim, there's a gap. How long is the gap going to be in existence? How long will it take for you to get lists passed? Who's going to pass it then? How is this going to work?
To create those lists for the other bodies, do you mean like the other bodies in Northern Ireland, like the policing board, etc.? It would be like a primary legislative change. So it's the capacity in our current mandate isn't there, so it would be into the next mandate before those could be created in that.
What about would you just address the gap issue for me?
So the gap issue, the vast majority of individuals that would be being added to the list are going to be from policing, you know, from PSNI. I admit there is a gap there, and if there's anyone dismissed from Northern Ireland Policing Board, etc. It's unfortunately, it's unavoidable that that gap's going to exist in the interim period.
There's harbour police, there's airport police, there's all of those bodies, and people could essentially move around.
Harbour police and the airport police they're actually under the remit of DFI, so they are more difficult to legislate for as well, given that DFI would be their sort of like governing department. So it would be cross-cutting that way.
Yeah, I'm not sure that I'm understanding why this. I can't see how much resources and time would be required to add these additional names in. It's not computing with me. Does everybody else get it and I don't? Do you all get it? Do you see why there's a reason?
It wouldn't be. They would be creating the lists on the face of that bill, so it's not a list of names. It will be saying who is the relevant authority for each one of those organisations, where the power comes for them and even who they employ, and how they dismiss those people, you know, whether it would be through employment law. So there is more to it than it would just be listing the organisations. They would need to be giving the legislate where the power for those organisations comes from with regard to employing people. For example, with the PSNI, the officers aren't employed as such, that they're set out in statute, so it's referencing where that comes from, the Police Act, etc. And it'll be the same for the Policing Board then for their employees, because then they are employees, so it's employment law and how they would then be being dismissed through appropriate processes and the appeal mechanisms then that they have. So it's not as simple as just listing organisations. It's going to have to demonstrate where the power for those.
No, that's fair enough. That's a bit more clear. But I suppose it still leaves us with a gap.
Yes.
That could potentially be exploited. I don't imagine there'll be huge numbers, but there's a gap there and could potentially be exploited. Have we any indication from the Minister about the prioritisation within the next mandate to deal with these gaps?
I'm not aware of that at present.
I mean, if I could just intervene in terms of plans for potential legislation for the next mandate, I think we will be starting to have those discussions fairly soon. At the moment, our focus has been on getting our 3 bills introduced or scrutinised by the Assembly, and then these 2 legislative consent motions. We have actually just expanded the capacity in the department in terms of legislative planning and monitoring, and that will actually fall within my team from now. So we're going to be putting a communication out to the department probably in the next month or so, just asking for initial ideas for a very long list of what might be included, subject to ministerial and executive approval after the next election. So part of that work will be prioritising for our purposes what might need to be in an earlier bill of the next mandate compared to something that might be safer to be left to later on. So we are going to be starting that work very shortly.
Yeah, because presume you've got a lot of stuff that you're going to have to carry over anyway, that you haven't been able to fit into this mandate.
Absolutely, yeah. I mean, I've already a fairly long list of my own without having to ask anybody else about it. So.
Got it. Okay, that's great. Thank you very much. My next question just relates to the knives issue. I just want to absolutely understand where this is coming from, understand the risks with this type of crime and so on. And you know, I think none of us have any issues with the safeguards that are in there. I just want to establish practical things. You know, people buy knife sets as wedding gifts. People have it on their wedding register. You know, how in practical terms, how is this going to work?
Yeah, so for the sale and delivery, the first provisions really are putting in strengthened age verification requirements. So at the minute, a retailer, they're required to show due diligence in checking someone's ID, but there's nothing to explain what that is, I suppose. So these provisions would require the seller, it sets out what they need to do. They need to actually physically check somebody's driving licence or passport against a photo before they make that sale, and similar for delivery on those ones. On the bulk sales then, there are, for things like as you described, that wouldn't be included. It's really the purpose behind it is to stop people buying, say, 20 knives online and then selling them on Facebook or social media, and there's no way to really track where they go. So it's not targeted at those like cutlery sets and things like that. It's really to flag to police or others that someone is buying bulk sales of knives that aren't in that cutlery kind of remit.
Okay. I just kind of wonder about things like how it's going to work. You know, people order some of this stuff on Amazon and all that, and chef's knives and all that. And anyway, Ciara, it's the same about alcohol online.
I can understand obviously the physical presentation of their ID and checking it, but online, how do they propose to do it?
I think because it'll be following remote sales. I can come back to you on that, but I think they'll have to be required to send a copy of their, like, I don't know actually, I'll double check how that works for the online. When you're not in their physical presence.
And then the number 6, where does that come out of? Like you could go around a few sites, get 5 each. It's not long before you can have more than 6.
Well,
you know what I mean? So just wondering where the 6.
Yeah, no, I can come back to you on why 6 was picked rather than the 5.
Fine.
Yeah,
that's grand. Thank you, Emma.
Thank you.
All right.
Yep.
Hattie.
Just on that, what's the definition of a knife?
So it's not actually knife, it's a bladed product rather than a knife. So it's the same definition within the Offensive Weapons Act. So it's like a it's quite confusing. It's a subset of a bladed article. So it's any blade that could cause harm to the skin that somebody could.
If you're buying multi-packs of
check there on Amazon.
Razors to shave your legs.
Sorry, I'm maybe confusing the two provisions with the sale and delivery and the bulk buying. So there's different definitions depending on the provision. So there's like 3 different definitions, but I can set that out for you, in writing.
That point is, a knife's a knife. It's the use it's put to.
Yeah.
And in the hands of the individual and the intent that person has. But if they go on Amazon and buy a range of knives, ostensibly for cooking, could be under a high-profile chef's name or something like that, how do you control that if it gets into the wrong hands?
If they buy it and then it is then passed on to someone else, is that no?
No, but what I mean is that's legitimate sale of a knife for a purpose.
Yep.
It's the end user and what that person uses it for.
Yes, and
but how do you control the sale of that knife? You can't.
No, I think I get what you mean. So somebody could legitimately buy it, but then it ends up in the hands of somebody else. Is that Somebody could go on Amazon as long as they have a credit card and an account and buy a set of knives. And the sale, the clause 31 then, that would require them to, it's really these provisions are to prevent them getting into the hands of under 18s. Following the incident in Southport last year where a 17-year-old was able to buy a blade online.
But that blade could be within the household.
Yeah.
Somebody could have bought it for legitimate purposes if the Amazon's full in there. They get into the house, how do you prevent that person from getting the knives that are in the cupboard?
Mm-hmm. And yeah, no, it is a very good point. Yeah, I don't think this will cover that. But.
Hear you?
Anyway,
No. Ours is just a agree or not an LCM.
aye, I know.
Okay, and that's been, like, it's the same issue for me with some of the sentences and stuff being sent for, summary, where, like, some of that stuff, I think should carry way heavier sentences than is proposed, but then that's the government, so not our call. Right, does anybody have anything further? No? Folks, thanks so much for taking the time today. We really appreciate it. We know that it's quite a lot to kind of come up here, and so many of you coming away from your desks and so on, so thank you very much. We appreciate you answering our questions.
Okay.
Thank you. Doubtless we'll see you all again in various stages and guises, but thank you in the interim.
That's it. Thank you very much.
Members, the committee had previously written to the Committee for Health to ask to be kept informed of its consideration of the provisions to be included in the second LCM that are within the Department of Health's remit. Can I have your agreement to forward the relevant extract, which is about the removal of supervision exemption from the definition of regulated activity from the Department's paper to the Committee for Health, to request any views or comments that committee wants to make?
Agreed.
Agreed? Thank you. Agenda item 6 then, Justice Bill written papers. So item 6.1 is a paper, it's the consultation on proposals to criminalise sexually explicit deepfake images, and then 6.2 is the Department's response regarding the Justice Bill proposed deepfake amendments. We'll take those together, and I would ask you to turn to page 96 to 31 for the first part, and 132 to 136 for the response. The Department had advised the committee of its intention to run a consultation on these proposals about criminalising sexually explicit deepfake images, and officials provided oral evidence on the draft consultation at the meeting of the 26th of June this year. The Department has now finalised the consultation and launched the consultation, and it's going to close on the 6th of October, not the 29th of September, as the covering letter would indicate. The Minister has conveyed her thanks to the committee for its careful consideration of the draft consultation. During the oral evidence session, the officials agreed to provide information clarifying whether there's a deadline for social media companies to remove illegal content from their sites and to share the Department's Human Rights consideration and the Northern Ireland Human Rights Commission's comments on the proposed amendment when available. A response from the Department, as I said, is found at page 132 to 136, and they've advised that when alerted to or when they become aware of illegal content, providers of user-to-user services are required to, in quotes, swiftly take it down. The Department has shared its human rights considerations from the consultation document and advised that the views of the NIHRC on the legislative proposals will be provided to the committee as soon as they're available. Are you content to note that consultation paper and response and consider further when the results of the consultation are available, or do you have any further information or clarification that you require at this point?
Intent to note, and then we'll consider it when it comes back.
I think that's fair enough, although I think we'd want to be doing some querying around swiftly there. Doesn't seem to be, maybe something that's a bit more definitive, but that swiftly is what we've got for now, so we can probe that a bit more further. Item 6.3 is again the DOJ response regarding access NI filtering arrangements. I would remind members that our meeting on the 26th of June this year, we considered Assembly Research and Information Services paper on the proposed access NI filtering amendment to the Justice Bill, and we agreed to forward that paper to the Department for a response to the scrutiny points included. You'll see the response from the Department is at page 139 and going on to page 144, and in that it states that it considered the content of the raised briefing paper and would regard it as full and accurate summary of the access NI filtering journey over the past number of years and the outcome of the review of the list of specified offences in 2023, which have resulted in the current proposed legislative amendments in clause 29A of the bill. The Department would not seek to contradict any of the points noted in the paper and has also responded to each of the 6 scrutiny points offered by the paper. Are you content to note this response, or do you require any further information or clarification at this point? I would just remind members that the Access NI people are coming to the committee on the 2nd of October. So, I mean, we can probe some of these issues further, but for now, are you content to note? All right, thank you. 6.4 is again DOJ and its response regarding the Justice Bill proposed restorative justice amendments. At our meeting on the 26th of June, we considered the Department's responses to questions that it had asked about the proposed restorative justice amendments to the bill, and we then agreed to ask the Department for further information on a number of matters. The Department's response is page 146 to 148, and officials have offered to provide further clarification to the committee if we require it. Are you content to note the paper, or do you have any further information or clarification that you require?
Noted.
Content to note? All right. 6.5, again DOJ and its response regarding reasonable chastisement and equal protection. At our meeting the 12th of June, we agreed to seek further clarity on whether the availability of sufficient and effective support mechanisms for parents are being fully considered in parallel with any proposals to remove the defence of reasonable chastisement, as well as information on any discussions the Department was having with the Department of Health to ensure that such support mechanisms are in place. At the same meeting, we also agreed to request a joint evidence session with officials from the Department of Justice and the Department of Health to discuss reasonable chastisement and equal protection. A response from the Department is located at page 151 to 159 of the pack, and in that they state that there's no evidence from other jurisdictions where the defence of reasonable chastisement has been repealed, that doing so risks criminalising parents who simply need additional support. The Department also advises that in the absence of executive agreement to progress with the repeal of the defence, there's been no active engagement with the Department of Health beyond the Minister's meeting with the Health Minister in July 2024, and again to secure information to provide replies to our correspondence. The Department requested that ahead of any agreed date for a joint evidence session with the Department of Health, the Committee inform them of what issues or questions members would like to explore at the session to ensure attendance of the most appropriate officials, and that's fair enough. What they're saying is then they would like our views on topics and or questions the committee wishes to address with the DOJ and DOH officials for that future evidence session. And it would seek the agreement of members that these would be relayed to the DOJ to enable them to move forward. A couple of things I want to point out. We've got a strategic planning day in a couple of weeks. And also the NSPCC and a senator from Wales is coming on this issue to the Assembly in a couple of weeks. And you'll see later in the pack there's an invitation to meet the committee. I would suggest, I mean it's going to be the committee's decision, but I would suggest that any decisions and queries around this, unless people have them now, I mean you can be thinking about it in the interim, but my view would be think about it in the interim, hear the briefing, and then sort it out at the strategic planning day, how you want to proceed. That's kind of my thought on the, because it's only a couple of weeks. Danny?
Yeah, no, I was just going to say, I think the joint meeting is going to be very important, and there'll be a lot of information that will come out of that from both of them. We may not have all the questions right now, but I think we need to start building up what is needed between the two departments if this was ever to be progressed. So I would just suggest that we make sure we do get it in the diary.
Well, at the strategic planning day, I think we've got tables that the committee staff prepare that show us where the gaps are in terms of what we're looking at and what evidence we've got and where we need to get evidence and who else we need to talk to and bring in. And I think that document will prove really useful for strategic planning. At this point, there is nothing in front of this committee with regard to reasonable chastisement. So, and it's not going to come from the department, so it's going to come from a party or a member or a couple of parties or whatever. I think that it will be helpful for members to get some of the briefings underway so that if you're going to any meeting, if we're going to any meeting, we're actually coming there informed rather than just kind of bouncing in. Also, I'm conscious that we've got a lot on our plates already, so doubtless it'll come, but there's stuff that we absolutely have to deal with because it's already there. But again, that's for that's the committee's decision. I suppose what I'm saying is, can we hold off till we've heard the briefing from the senator, which is on the 22nd of September, and then the strategic planning day is on the 25th of September, so that all kind of comes together. Does that work for everybody?
Can I come back in?
Yes, Danny.
I suppose sort of what I want to get and drill into was just the last time when the minister was in, she sort of indicated that without health at the table, and without us exploring that, it will never progress. That's sort of my point. But listen, I'm happy enough to wait as long as we're definitely going to get it in. And I think it's fair.
No, I'm good.
Yeah, I mean, the decision to put that in or not, Danny, will be the committee's, and I think the committee will have a clearer picture at strategic planning day. So, everybody happy enough with that? Yeah? Yeah. Right, okay. Item 6.6 is DOJ response regarding children and young people's understanding of diversionary disposals. At our meeting on the 3rd of July, we agreed to ask the Youth Justice Agency for further information on any concerns it may have in relation to children and young people's understanding of diversionary disposals and of the wider custody and questioning processes and procedures, following reference to such concerns in correspondence to the Committee from the Human Rights Advisor to the Northern Ireland Policing Board. And as I recall, actually, the Law Society raised similar issues whenever they came to give evidence. A response from the department is at page 164 of your pack. Are you content to note that, or do you require any further information or clarification? Content to note? Thank you. Item 6.7, again DOJ, its response regarding the bill and its photographs as biometric data. Just that small issue. At our meeting on the 26th of June, we agreed to ask the department for a response to several questions in relation to the potential for photographs to be processed in such a way that they should be considered biometric data. We also asked for the department's view on the definition of biometrics as applied in Scotland. You'll see the response from the department at page 169. Are you content to note that paper, or do you require any further information or clarification?
Sure.
Deirdre.
Just to raise my concern with the department's response, because I would argue that the weight of evidence shows the opposite to what they're saying. That once photographs are uploaded, they then become biometric data, and I think we've heard that in the evidence session. So I know we'll come to it when we're looking at the clauses and stuff, but I just completely refute what the department have communicated with us. And I do believe that photos are biometric data and should be treated as such, particularly when you consider the amount of images that the PSNI hold, just as one organisation. And as even the department have said themselves in terms of the emergence, because obviously we want to look at our legislation as future proofed. Mm-hmm. So just how this landscape is going to change, and I think to try and go back and do it after you've done this legislation, I think there would be one thing the public would be saying, well, why wasn't it part of the original bill? So I just want to put that out there at this point, and then I know we'll come back to it.
Look, it seems to me, and again, the committee's got to have its deliberations on this issue. I think it'd be really helpful. I mean, obviously there's a response in there from the PSNI, and we'll come to that too. As we work through this, and as we come together to establish, right, what is the evidence that we have, and where are we? Where are our opinions on these things? I think that'll be really helpful for us to establish as we're coming towards the end. Who else do we need to hear from in order to be able to form opinions, and actually really nail this down? And it strikes me that our scrutiny of the thing needs to be, work our way in and then work our way back out, because we need to understand how it's going to work in practice. So I don't think we're done with this yet, and I think I envisage certainly there are a number of these amendments that I would wish to be hearing from the PSNI again about the practical implications, even of some of the responsibilities they're about to be given, in terms of resourcing and how it's going to actually work in practice for them. So I still think that there's work to be done on that, and we'll take that on board if members are content at this stage to hold until we start to work through these issues.
I just come in, I just want to reiterate at this stage, I think it's a major shortcoming on this bill in relation to not recognising photographs. Once they go onto the computer, they're being processed. They're biometric data. I just want to reiterate that's where I am based on what we have seen, and I just think it's hugely ridiculous not to proceed with this bill. Do not include photographs, because as soon as this bill is passed, the very next day we were going to have to look at photographs. So I just want to reiterate it at this point.
Look, it's fair enough, and we've discussed it at length. The future proofing, what constitutes, why it's not included, and all the rest of it. And I get it, and I agree, because I think privacy at this stage, privacy is one of the biggest issues that modern society faces. Mm-hmm. And these are not small issues for anybody in society, and trying to find the balance between public safety and a person's right to privacy. and indeed that day of the opening of the legal year, the lecture was about that very issue, about privacy in the digital age. So, this is a worldwide issue. And happily this committee takes it very seriously. Right, on the same note, item 6.8 is PSNI's response regarding the Justice Bill and photographs as biometric data. So you'll see the responses there from the PSNI at page 175, 176. Do you want to note that for now, or do you require any further information while we're on it? Deirdre?
I've noted for now, but as you say, I think we will want the PSNI in again on different aspects of the
I think there's a lot of
biometrics.
stuff.
So
Serious and organised crime isn't
Yeah.
doing what it says in the 10. I mean, there's a lot of
Yeah.
stuff there we haven't even started to probe yet.
there may be things we'll come back
Yeah.
to, and I suppose we can highlight the PSNI before they come what we want to talk about.
Absolutely. Right, 6.9 is the Minister of Health and its response regarding unregulated bail placements. At our meeting on the 26th of June, we agreed to ask the Department of Health for information on the number of children and young people placed in unregulated settings following oral evidence from VOIPIC and include youth regarding suitable bail placements. You'll see the response to the Minister of Health located page 179 and 80. Are you content to note that response, or do you need anything further?
Content to note that, well, I'll just make a statement. I don't, whether it's 1 child, 5 child or 20 children, no child should be in unregulated, so I just want to emphasise that point, because it's still a really, really important issue, and I don't think by having a small number makes it any less important to ensure that there is appropriate accommodation for children.
Yeah. The bail issue is very difficult. Right. Item 6.10 is the Children's Commissioner, Young People and Children's Commissioner, advice to the government, which is their response to the Justice Bill amendments. So the Commissioner for Children and Young People has provided written evidence to us around the proposed amendments to the bill, and you'll see those at page 183. Are you content to note that paper, or at this stage do you need anything further?
Note at this point, and then we'll pick up on it as we're going through. Yeah, it's useful paper.
Item 6.11 is Northern Ireland Alternatives and Community Restorative Justice. There's a joint written response to the Justice Committee. You'll see that Alternatives and CRJI have given joint written evidence paper to the committee on the bill, and you'll find that at page 199. You'll also see in the table pack there's an email from them both. That's at page 12, and that says that they would like to give oral evidence to the committee on the bill, or as a first step to meet with the chair and deputy chair. I mean, I think if they're going to give oral evidence, they probably don't need a meeting with us. And I think anything that they have to say probably would be better and more beneficial for the entire committee to hear that, and to have a formal setting where people can ask them questions that they need. So are you content with that then, to invite them to come and give oral evidence?
Great.
Yeah.
Right, thank you. Item 6.12 is VOIPIC, and it's a response following the oral evidence session on the Justice Bill that they gave on the 26th of June. At that meeting, we asked VOIPIC for details of any engagement they've had with the department, it's our department, regarding reframing the language around children and replacing juvenile with child, as well as for a copy of the document 10 Reasons Why 10 is Too Young regarding the minimum age of criminal responsibility. So that response from VOIPIC is located at page 215 of the pack. Could I ask you to note that the consultation response which they've provided, and that starts at page 216, is in draft form, and they've requested that we don't share that document on. So could I ask you, are you content to note that response, or do you require anything further at this point? All okay?
Yeah.
Right. Item 6.13 is from an individual, and it's a response regarding the Justice Bill call for evidence. So we've received an updated response from an individual regarding our call for evidence in the bill, and that response is at page 221. Are you content to note that for now, or do you require anything else?
Noted.
6.14 is Children and Young People event in the Lawn Gallery on the 3rd of July, and that's the draft notes. So that day we held an event with children and young people to hear their views on aspects of the Justice Bill and the amendments, and the team has compiled a draft note of that event capturing the most salient aspects of the event and the young people's evidence that day. That note is at page 224. Are you content to agree that note? Yeah,
Great,
thank
sure.
you. Yes, dear.
Just to use the opportunity, I suppose. I mean, I thought it was a really good event.
It was.
The young people were excellent, and I suppose just thanks to the team here, obviously, for organising it, and then also to the support organisations that came with the children and young people as well. I mean, I thought it was worthwhile doing, and them getting to meet the committee and stuff, and I think they got a lot out of it. And I think it's a good way for committees to engage with the public in terms of legislation. So again, just to put that on the record.
I thought it was a really good event.
Chair, just to on the back of that, the preparation actually was really aided by VOIPIC and Include Youth, because they're the experts in that field. So if the committee's content, we'll convey the committee's thanks to them as well for their input to the event.
Maybe not the quiz so much.
They got us up and moving.
Willie Hay just didn't get it all.
Right, what do we see? Yeah, so we're content to agree that draft note. Are you content to issue the finalised agreed note to VOIPIC and Include Youth and ask to be shared with the other organisations who ran that event? Yeah, agreed? Thank you. Members, can I have your agreement to publish all of these papers 6.1 to 6.14 on the Bill web page in line with usual practice, with the exception of that draft VOIPIC paper? Yeah, great, thanks. 6.15 is request for further information. That's page 230 to 261 of the pack, and that's the document that the team tracks everything with. Are you content to note that? Thank you. 6.16 is the Justice Bill. It's the table with the departmental responses up to September 2025, page 262 to 341, and that sets out the issues we've raised and the comments made and the written and oral evidence received against the various clauses and the proposed amendments. That table is normally issued to the department at the end of the evidence gathering stage for its response to all the issues raised. There has, however, been significant engagement and correspondence with the department on a number of these issues, so the committee team has sought to add any available responses to the table. Are you content to note the table?
Noted.
Yep. Right. So that table then is going to be added to the bill folder along with all the other papers that have been included in today's pack. Agenda item 7 is the raised written paper, and that's again for the bill on the organised crime amendments. So that's page 343 in your pack. Raise has prepared that paper, and it provides an overview of the amendments to the Justice Bill relating to organised crime. A number of scrutiny points have been included in that paper, and they can be found at page 371 to 372. Since that pack was issued, a revised paper has been provided which reflects the department's plans relating to the Crime and Policing Bill. And the scrutiny point at the 5th bullet point at page 371 of the pack has also been updated, and it reads as follows. Has adequate consideration been given to the potential impact of the participating offence on children and young people who are being abused or exploited by organised crime gangs? How will child criminal exploitation prevention orders be implemented in Northern Ireland? What awareness raising will be undertaken in relation to the child criminal exploitation offence included in the Crime and Policing Bill, which will apply across the UK? So a revised copy of that paper is going to be circulated to you after the meeting. Are you content? Yeah, and are you content that we would forward the updated paper to the department for its response to the scrutiny points? Yeah?
Yeah.
Great, thank you. Agenda item 8 is an SL1 around the Coronavirus Act. I'm not going to read the full title of it, we're all very familiar with it. It's the live links for courts and tribunals. That's at page 74 to 390. The department's proposing to make a statutory rule under powers conferred by section 90 of the Coronavirus Act 2020, and it's proposed that the rule will come into operation on the 24th September, and it's going to be subject to the confirmatory resolution procedure as normal. This is obviously one of the series of sequential rules to enable live links provisions for courts and tribunals to remain in force for a further 6 months beyond 23rd of September, and it's an interim measure because we know that there's stuff coming forward in the bill. Are you content with that statutory rule to extend the live links?
Great.
Thank you. Agenda item 9, Department of Justice Retention and Disposal Schedule. I'd ask you to turn to page 391. A copy of the Department's the DOJ's R&D schedule was laid in the Business Office on the 3rd of July. The schedule is required to be laid before the Assembly under Section 8.2 of the Public Records Act, Northern Ireland, 1923, and in accordance with the rules of the Disposal of Documents Order 1925 by the Public Records Office of Northern Ireland. The retention and disposal schedule is subject to the negative resolution procedure, and the statutory period ends on the 7th of October this year. So as a public body, PRONI falls under the responsibility of DFC, and a copy of the retention and disposal schedule was therefore also issued to the Communities Committee. Do you want to consider asking if the Department of Justice is going to detail how the schedule differs from the previous version, or are you content with it as it is?
Oh, that would be useful.
Yeah, we can.
Deirdre?
I think also one that just stuck out, and it was probably more just of interest, I wonder why it was on page 433, regarding it's 10.14 on that page, and it was just the Ministry of Defence case files. It's the only one where the files aren't either destroyed or put into pronates, where they're transferred back to the MOD. But it's just, and the rest then are destroyed. Now I know they were saying it's an MOU, but I was just wondering what that pertains to then, so why the rest wouldn't transfer and that one does. Just it sits out like a sore thumb nearly, really, that's all in the rest of the schedules.
Do we want to clarify that then?
It's just a query on it, yeah.
Okay.
Thanks.
And we want the differences as well, that's fair. Members agreed?
Agreed.
Okay. Right, now here's the other thing you need to know, because we're not holding a formal meeting the 25th. We'll need to decide by the 18th of September if we're happy with that schedule or if we want to pray against it. So you have to bear in mind that it's not likely that the further information you're going to request from the department you're going to have in time to make a decision on the schedule. Okay? So do you want to decide today whether or not you're happy with the schedule?
I think if they can try and get the info for next week, if not then we'll know that we'll have to make a decision.
Okay. Members agreed to that then? Okay. Agenda item 10 is DOJ Corporate Plan 2025-2028 and the Business Plan 2025 to 2026. And there's a DOJ written paper. I'd refer members to page 472, and it's the start of those in the pack. So they've sent us a copy of the DOJ's Corporate Plan, and the Business Plan has been received, and as well as a summary of progress against the Department's Business Plan for 2024-25. As noted in the paper, the Perm Sec is due to appear before the committee in the coming weeks, and the Department has advised he'll be happy to address any issues relating to these documents then. Are you content to note the Department of Justice's Corporate Plan and Business Plan, or do you want any further information and clarification at the time? I just want to flag up to you too, the Permanent Secretary, his attendance at the committee has been delayed because he wants to go and meet the Criminal Justice Board, and that's due to happen in September. The thing that struck me about those documents, and it was honestly it was a cursory glance, but look, so Jenny produced a report that said the department was stagnating, and that they were kind of desperate and operating in silos and not pulling in one direction with an agreed vision. So I appreciate that the Perm Sec and presumably the Minister and the Criminal Justice Board working on that. But I see nothing in that document that actually addresses that point. I see nothing. And I would be wanting reassurances whenever the Perm Secretary comes. I mean, how, if they've produced this document now, how are they going to address the issues that have been raised in that really significant Susanne report? And the other thing that I want to say about that Susanne report is this. I feel at times the hamster wheel of this committee, as we try to work through bills and the raft of issues that there are, means that we are very busy looking at the trees and not the wood as a whole. And I think that if Susanne says there is stagnation and Susanne says there has been little progress in the criminal justice system for anybody engaged in it in this past 15 years, I think this committee has a responsibility to not tie itself up in the hamster wheel, but actually to step back and take a look at what is going on and what we can do to try to make the system better and that the public can have greater confidence in it. So, Doug.
Chair, no, I completely agree with you. And that Criminal Justice Inspectorate report, November last year, gave the department 6 months to come up with a shared vision and strategic priorities for the Criminal Justice Board. 6 months from November. Yep. We're well out of that scope at this moment in time, and it affects absolutely everything. So we literally have a probation board which is working in a different silo to the prison service, which is working in a different silo to other organisations. And I think it's appalling. And I've been highlighting the case of James Meehan up in Londonderry, who was allowed out on day release. Only the family were told 2 months before he was released that they had made a decision that he was not to be released. and they would review that in 10 months' time. And I think it's appalling, and I think that goes to the root of what you're actually saying, is there's no coherence in our criminal justice board, there's no coherence in our justice system, and I think we really need to dig into this and hold the department to account on that particular issue.
Absolutely concur. I mean, the day that Susanne was here, the Chief Inspector told us that they were expecting a response from the department imminently. The department has now come back to us to say it requires more work than that, and Susanne has been notified that they would require more time than the 6 months. However, we are a considerable period on, and that was why the committee agreed to have the Permanent Secretary here. It may well be that the committee actually needs to have the Minister here to look at that, but either way, I think we need, as a collective group, to ensure that, you know, in the churn of our weekly work, we don't lose sight of that bigger picture, because that's as damning a report as I've ever read. Right, everybody content with that then?
Yep. I think it'd be good then to get clarity on when, if it is the Permanent Secretary, when he can come in. I think if we can highlight our concerns then around progress on the Susanne recommendation, and to get clarity on when they can have that, so that he can present that as part of oral evidence here. And could we also then get Susanne's view on an extension to that deadline then of work, to make sure then that we're not dropping this, and we're going to look at this in this autumn period as part of our committee scrutiny. And then we can pick it up maybe on the planning day as well.
Members agreed?
Agreed, yeah.
Thank you. Agenda item 11 is legal aid, general authority and ministerial directions, DOJ written paper, starting at page 516. At the beginning of May, the department informed the committee of its plans to take forward a short consultation on a draft general authority and direction to give effect to supporting changes around enhancing legal aid remuneration. This included increases to PACE, immigration and asylum, and advice and assistance limits, and changes to the interim payment of disbursements. The department has provided an update on the response to the consultation with statutory consultees, and a copy of the general authority increasing the advice and assistance limit to £2,000 for PACE work and £1,000 for immigration, asylum and human trafficking work has been provided, along with a new direction which decreases the lower limit of the interim payment of disbursement from £350 to £250 and raises the upper limit from £2,500 to £3,500. The department has also advised that the Enabling Access to Justice Programme business case is being finalised, and once approved, the department will make arrangements for the publication of the general authority and direction, along with supporting guidance to coincide with the legislative amendments coming into effect. An amended copy of the report on the response to the earlier consultation on amendments to legal aid remuneration has also been provided, as the previous version failed to acknowledge that the Bar of Northern Ireland had responded. The department states, however, that the Bar's views were taken into account in finalising the policy proposals and impact assessments. Are you content to note the department's papers, or do you require any further information or clarification? Ciara?
It's just obviously a welcome we've got to this stage, but I would like more information on expected timeline for the business case. And likewise, has the range of stakeholders that are involved, are they aware of when this business case and what has been their response? You know, are they aware when?
If you'll bear with me, there's a couple of things I think that we need to be writing to the department about. Now look, I am conscious that I have an immediate family member who works in the legal profession, and I've never shied away from that. However, this committee gave me permission to attend the opening of the legal year. And while I was there, I was approached by the president of the Law Society and at least 3 or 4 other solicitors, one of which was not my immediate family member, I would hasten to add, because we keep those things very separate, and we endeavour to do that. But at that stage, members will remember, the Minister had agreed that there would be a 16% increase, and that was agreed in May, and it was to be implemented fairly quickly. Then that was it was put back, and each time it was going to be, it'll be May, it'll be before the summer, it'll be July, it'll be now. They don't really know when it is, and there are concerns of bad faith, as you will appreciate. There are also concerns that in the interim period, while this is not moved forward, that firms could close. It is not clear there either whether a business case has been prepared, never mind presented for approval. And I think that we should be establishing what is the status update with this, because that was supposed to be moving really quickly and it hasn't. The other issue that was brought to my attention, if you'll bear with me please, I just need to look it up because I took notes on it and I didn't have my notebook, so I had to message myself, was there's an issue about county court. Just bear with me a wee second. Sorry, you know when you're looking for something. Here we go, right. So, I was advised that
Do the wee notes.
county court scale fees, so apparently this is an administrative thing, goes to the department, went to the department in December, and there's a response usually within weeks. Nothing has been forthcoming since December. There was a meeting in July, still nothing forthcoming. At that meeting they were told it would be sorted out within 2 months, still not done. Now, and they tell me that these fees haven't been increased since it's 2017, but it turns out the 2017 increase included an increase for 2018. So kind of 2017-18, this hasn't been looked at. So none of that has been done. And essentially what they were asking me to do was, can we flag this up and get a status update on where things are and what business cases have been presented, if at all. Are they prepared? Have they been presented? Where is it? Because this stuff was all supposed to be done. That's going on from December, and the other stuff has been going on from May. So are committee members content to do that?
Yes, very much so, yeah.
Now, I would stress that I was there as a committee representative at that event, and I was approached by several people, so that's where that's coming from. Is that okay?
Yeah.
All right. And then we can add in Ciara's point, obviously.
Yeah,
Right, agenda item 12 is Northern Ireland Courts and Tribunal Service Business Plan 2025-26, and that's a written paper from the department at page 542. You'll see the department has forwarded to us a copy of the business plan to note, and the plan highlights a series of actions under each strategic objective in support of the court service corporate aims of working in partnership, supporting the judiciary and modernising courts and tribunals. Are you content to note that business plan, or do you need anything further? Noted? Noted, yeah. Thank you. Agenda item 13 is Director of Legal Aid Casework Annual Report 24-25, Corporate Plan 25-28 and Business Plan 25-26. The department's informed the committee that it's now laid before the Assembly the Director of Legal Aid Casework Report for year 24-25 and Legal Service Agency's annual accounts for 24-25. In addition, the Minister has approved the Legal Service Agency's corporate plan for 25-26 to 27-28, and that includes the business plan for 25-26, and all those plans are available at pages 565 to 593. Are you content to note those, or do you need anything further? Content to note? Noted. Thank you. Agenda item 14 is correspondence. There is a correspondence memo on 46 items of correspondence, starting at page 597, going on to 1557. I'm going to draw your attention, as I always do, to a couple of the items, and then you'll have an opportunity to comment on any other items of correspondence in which you've got a particular interest. So item 14.2, that's correspondence from the department at page 605, and that contains the department's response to a number of matters raised by members on Susanne's report, Transforming the Criminal Justice System in Northern Ireland, a strategic overview, and the committee's oral evidence session with the Susanne Chief Inspector on the 29th of May. Can I ask you to note the response at this stage and consider further as part of the planned oral evidence session with the Permanent Secretary?
And our planning day as well then.
And the planning day too, yeah. Members agreed?
Agreed.
Okay, 14.18 is correspondence from the Committee for the Economy at page 821, and that contains an invitation for the views of the Committee on the Insolvency Amendment Bill. Can I have your agreement to provide a nil response, or does anybody want to respond? Agreed to nil response?
Yeah, we can do.
Thank you. 1419 is correspondence from the Committee for Agriculture, Environment and Rural Affairs, page 826, and that contains an invitation for views of the Committee on the Dilapidation Bill. Are members content to provide a nil response?
Agreed.
Thank you. 1428 is page 1134 of the pack, and that's correspondence from Cara Hunter, MLA, providing a link to her consultation on our proposed private members bill, Victims of Sexual Crimes Trauma Mitigation Bill. Do you wish to consider a committee response, or are you content to provide responses via your respective parties? Parties?
Yeah.
Okay. 1429 is correspondence from Timothy Gaston, MLA, at pages 135 and 36, sorry, 1135 to 36 of the pack, requesting to register the NI Survivor Council as a committee consultee. Can I have your agreement to add them to the committee's consultee list?
Mm-hmm.
Great, thank you. 1430 is at page 1137, and that's an invitation from Voipic to the Show Us You Care launch event in the Long Gallery on the 2nd of October. If you wish to attend, you should RSVP to Voipic directly via the address in the invitation email. Is that okay, everybody?
Yep.
Yeah.
Thank you. 1431 starts at page 1140, and that's an invitation from the NSPCC to a reception on equal protection for children in Northern Ireland, and that's taking place in the Long Gallery on Monday the 22nd of September. Julie Morgan, who's a member of the Welsh Senate, will be the keynote speaker at that event, and the then Deputy Minister for Social Services, Miss Morgan MS, brought forward the legislation to remove the defence of reasonable punishment. As part of their invitation, the NSPCC has offered the committee the opportunity to meet informally with Miss Morgan in advance of the event. Can I have your views on whether you want to have that or whether you just want to go to the event?
What day is it, sorry? Is it
Monday.
on
It's
the
a Monday. We want to do it Monday morning when we all have group meetings. So
No, I'd just go to the meter at the event.
right, are members content with that then?
Yeah.
Right. Item 1432, it's page 1142, and that contains various correspondences from an individual which seeks clarification from several departments on a number of different matters. This individual has also written to the DOJ seeking clarification on the department's statutory and policy responsibilities in relation to private and public family law proceedings, particularly where domestic abuse is a relevant factor. The individual has requested to meet the committee to discuss in greater detail the concerns previously raised in relation to the family court system in Northern Ireland, specifically in the context of domestic abuse, safeguarding and access to justice for victims and children. I'm seeking your views on how you want to respond to the individual's request to meet with the committee. Ciara?
Given this is ongoing and we've all kind of raised concerns, and we've had a series of meetings, I would be keen to have the opportunity for them to come to committee to further detail the information. Now, I do know that we are planning our strategic planning day, and we thought that's where we'll agree finer detail of what we can do and what we can take forward and what we can focus on. And obviously this is a key area that I would be very keen and passionate about that we do focus on. So, and I'm understanding of the diary, but whether it's included within the strategic planning day as to when we meet them, it's obviously it's the committee has to make a final decision, but I'm just saying it's an area of work I would like us to prioritise on, and it's as individuals, because
it's an area of work we agreed to prioritise.
To hear, meet them and hear the voices within the committee, and
it's one person. That's so. This is so. Yes, firstly, it is an area that we did agree to prioritise, and we've moved forward to some extent on that in terms of the meetings we've held with the judiciary and the minister on it. I think you're absolutely right to take it to say let's take it to the strategic planning day, because I think we also need to consider in the bigger picture taking evidence from one individual on and whether or not, because it'll not just be one individual who's affected by this. So I think the committee will, I think at our strategic planning day, we need to look at all of those issues, because they're serious issues that have huge bearing on people's lives and children's lives. and we need to look at it, but we need to figure out the best way to do it and the best use of our time to actually get the things that we need out of it. Connie?
Yeah, thank you, Chair. I think just to concur with actually what both you, yourself and Ciara said, I don't want to preempt the planning day, but this is an area that I'm concerned with as well, and would love to see the committee do a piece of work around, but content for us to discuss further at that day the best approach to that.
That's great, thank you, Connie.
Sure.
Yes.
It'd just be helpful for that day, just from the team around. I mean, I know there's options for like a committee inquiry, because obviously a lot of members have. I'm not saying that we're going to do that, because we obviously have to balance what we're going to do against our work programme as it is around legislation.
Well,
but I think just what
what
options do we have? And I suppose what's the commitment for each of those options, even if there's a kind of overview that we can be given, and then we can kind of discuss that amongst ourselves then at the planning day. I think is the most appropriate.
Sure. Everybody agreed?
Yeah.
Great, thank you. Right, 1434, starting at page 1187. You'll see that there's a significant amount of correspondence which has been received from an individual over the summer period, and the first, which includes a submission to the committee, has been included in the pack. Most of the correspondence received has been issued to other people or organisations and copied to the committee. Any member who wants to receive a full copy of the correspondence should contact the committee office. We're seeking your agreement to respond to the individual, advising that the committee has a strategic, policy and legislative role in relation to justice matters and does not get involved in individual cases, and that the individual may instead wish to engage with her political representatives or other administrative or legal avenues that may be available to her. Are members okay with that?
Yep, agreed.
Thank you. Items 1435 to 1438 and 1440 to 41. So items 1435, 36, 37, 37, 40 and 41 each relate to correspondences from separate individuals to the committee regarding their own personal issues. I'm seeking your agreement that as the correspondences relate to individual cases, that the committee responds to each individual, advising that the committee again has a strategic, policy and legislative role in relation to justice matters and doesn't get involved in individual cases, and that the individuals may wish to engage with their own local political representatives or other administrative or legal avenues. Are members content with that?
Yeah.
Thank you. 1439 is page 1309 of the pack, and that's correspondence that the committee was copied into from an individual to Alex Easton requesting a meeting to discuss matters related to domestic abuse in Northern Ireland, both within the family court system and across statutory services. Can I seek your agreement to respond to the individual copying in Mr. Easton, noting the correspondence and advising of the committee's continued interest and concern in relation to these matters? Members agreed?
Agreed, yeah.
Thank you. 1442 is at page 1324, and that's correspondence from a law student regarding access to the Bar of Northern Ireland for students. I'm seeking your agreement to request the agreement of the individual to allow the committee to forward their correspondence to the Bar and to the Department for comment. Members agreed?
Agreed.
Thank you. Also, members, there's a list of annual reports and accounts for bodies across the justice sector that were led over the summer period, and those are at pages 603 to 604 in the pack. If you wish to receive copies of any of those reports, you should contact the committee team. Are you content to note the other items of correspondence in the memo, or do you have any comments you wish to make on any of them? All content to note?
Noted.
All right. Forward work programme. The department's forward work programme is at page 1559, and you'll note at 1560 the permanent secretary was scheduled to provide oral evidence to the committee on the 18th September, but they've now requested, as I said, that be pushed back to allow him to meet with the Criminal Justice Board in September. So we're seeking your agreement to reschedule the evidence session with the permanent secretary after his meeting with the CJB. Content?
Mm-hmm.
Yeah. As outlined at page 1561, a written briefing on adult restorative justice has been scheduled for today's meeting, but the department had advised this couldn't be brought forward due to other work pressures, and it's hoped it can be rescheduled for early October. The draft committee forward work programme is at page 1562. Before the summer recess, we had agreed to hold strategic planning day following recess, so that event for the committee is going to take place that afternoon, the 25th of September, and it's going to be in room 106. All right. Can I have your agreement that the forward work programme is fine, subject to any changes we need to make? All agreed? Thank you. Agenda item 16 is chairperson's business. There's correspondence from the DOJ proposing a meeting between the Minister of Justice and the chairperson and deputy chairperson. So the Department has written to us requesting a meeting between the three of us in the near future. In addition to any matters we would wish to raise, the Minister would like to discuss enabling the Access to Justice Reform Programme, the legislative programme including the bill, the upcoming sentencing bill and the Victims and Witnesses of Crime Bill and the Crime and Policing Bill LCM2, the DOJ budget and PACE codes. So you can agree that the Deputy Chairperson and I go to meet informally with the Minister on behalf of the committee, or you can ask the Minister to come here. I mean, how do people feel about this? It's up to you. We've done both before, so any strong views?
When's the Minister due in again in front of us? Is there a date?
We don't have a date. You want to agree to the meeting? The Chair and Vice Chair will go for a meeting and we'll see.
Then feedback, and if we need a broader meeting.
Yeah? All right. We'll set that up. 16.2 is the Police Service of Northern Ireland invite to the PSNI and RUC-GC Senior Officers Dinner. I've received an invitation from the Chief Constable and the Deputy Chief Constable to attend the PSNI and RUC-GC Senior Officers Annual Dinner on Friday the 3rd of October. Our members agreed that I would attend that dinner.
Yeah, great.
Thank you. I should flag up that I used to be a trustee of the RUC-GC Foundation, but I'm no longer a trustee. 16.3 is the Police Service of Northern Ireland, and I've been invited to the highly commended awards ceremony. So that's a personal invitation from the Chief Constable to attend that awards ceremony. It's here in Parliament Buildings on Wednesday the 17th September, and I've been invited to speak at that. So I'm going to be attending that event in a personal capacity, and any remarks I make will be in that context. Is that members can attend? Thank you. Agenda item 17 is any other business. Does anybody have any other business? I've got one issue, and it's this. There's an issue about the DOJ's unlawfully at large list. Are you aware of this? No. So, a person went on the run in April, on the 30th of April after getting out on unsupervised temporary release. And this was found out in July by a journalist because every time it happened, it used to be whenever somebody went missing or absconded, it was put out to the public, either for warning to stay away and be safe or to help them to find the person who'd absconded. And it was sorted out that person was back within a day. But the issue is that there's nothing done to publicise that there's a missing prisoner anymore. There's no press release issued, and a disappearance is posted on a web page. So unless somebody's checking, whether that be journalist or member of the public, nobody knows that somebody, some of them with serious convictions, has absconded and is on the loose. So we're not clear why it is unpublicised. There's another couple of people who've been missing, and in fact they've been removed. They've been missing for a number of years, but they've been removed from the list altogether. So I think we need to have some understanding. It seems to me that that's a failure, and it looks like secrecy that shouldn't happen. The public should be made aware for their own safety and actually assist the police in the recapture of those who abscond. And I don't know where this policy has come from and why. I would like to know when it came into being, why it isn't being, what's the benefit there? I'll call you in a wee second, Patsy. But it just seems to me that there should not be a shroud of secrecy when people have absconded from prison, particularly and especially when they have committed serious offences. And I think we need to be asking some questions around that and seeking information from the department. Would members be agreed with that? Patsy, I'll come to you now.
My point was, what if there's a victim in the middle of this? Is that victim automatically notified, or they should be, where somebody has absconded from prison? That's not good.
No, so I'd like to have some understanding as well, how do we get to this point? And actually I think that needs to be fixed. I'm not sure it's sufficient to publish a website, and people can check it if they wish. you know.
Yeah, it could be just good to see,
I've got
was
you,
there a
Doug.
policy previously? Is there a policy change? Why?
Yeah.
So just to get more information and an understanding of the thinking then, so.
Yeah, and I mean, is it the committee's general feeling that it's not really acceptable to just update a website? I think we also need to be asking, why have these two people been removed from that list?
Get as much
course,
information as we can,
Yeah. Doug?
Maybe you should.
Yeah, again, you're right, Chair, and it's a serious issue. And to answer what Patsy was saying, are the families automatically notified? The answer is no, they're not. They're not notified unless they dig in to find out what's going on. And I think that is absolutely shameful. And that's fundamentally at the heart of the disconnect that we're seeing within our justice system, that people can abscond, and the families simply aren't told.
Absolutely concur. And it could be very damaging for somebody to just walk around the corner and there's somebody that's your worst case scenario, you know. So we're content with that then, yes?
Yes,
That's great,
yeah.
thanks very much. So agenda item 18 is date, time, place of next meeting, and that's going to be next week, which is the 18th September, 2 p.m. in this room. Thank you very much, everybody. The meeting is adjourned.
Committee Room 30, Sound.